Good morning, everyone. Thank you for joining us today and welcome to International Kinship Care Training. My name is Fiona Robinson and I'm the Senior Social Worker at Children and Families Across Borders. And I will be delivering this training with Maria Wright. Maria is a solicitor and she's our Senior Legal Officer. Here are our contact details. So in terms of the key learning objectives of today's session, we have quite a few. So they are as follows: the importance of international kinship care as an outcome for children, and how our international regulations are relevant, and how they're applied in care proceedings, and how to collaborate with foreign authorities. And we'll be looking at how to assess prospective carers overseas and also planning for a child's transition to an overseas kinship placement and arranging the post-placement support. The format of the training today is set out here. We will begin with an introduction to international kinship care. We'll just be looking at the definition. And then Maria will provide an introduction to the legal frameworks, and we'll be looking here specifically at what is known as the Hague 1996 regulation. And then we'll look at care proceedings, arranging assessments overseas, and placing children overseas. And this includes looking at planning support pre-placement. So we are providing a really sort of high-level summary of some of the most valuable points. Given the time limitations, we're not going to be able to cover everything in detail. Maria and I will be speaking for an hour and a half approximately, and we'll leave some time at the end to take questions. You can send us questions via the chat function. You can send them the questions throughout the training. The chat function allows us to see the questions and the moderators, but it's not open for everyone to see. And we'll do our best to respond to your questions at the end of the training, end of our presentation. So before we get into the details, I'll just provide an overview to our Children and Families Cross Borders. We're known as CFAB. For those of you who don't know us, CFAB is a charity. We're based in London and we specialise in international social work cases that involve the UK and at least one other country, and it involves cases with children who are separated from family members across borders. So we're staffed by social workers and caseworkers, and we all have sort of specialised training and extensive experience on working on cross-border cases. We offer casework services, but we also do provide a lot of other services. We also, in terms of delivering training to local authorities, we advocate for children's rights to be considered in policy making in matters relevant to social work practice. In terms of our case services, here's just a sort of brief overview of what we provide. We run a free advice line. It's open from Monday to Friday. It runs from 3:30 to from 10 a.m. to 3:30 p.m. each day, and members of the public and professionals can call in for advice on your cases or any concerns you might have involving a child that is overseas and you may need support with. We also provide a number of other specific case services. This includes passing on child protection alerts to other countries. We often are asked to provide this service if a family flees social service involvement to another country. So this might be Europe or elsewhere. We arrange social service checks in other countries, generally on the request of local authorities. And we might be asked to do this if I looked after a child or a child that's subject to a child protection plan travels abroad. We also arrange social service checks, where we seek social service checks from other countries, less often police record checks, but more often social service checks to inform child protection investigations, or if you're looking at doing assessments on foster carers, for example. But a bulk of our work really involves arranging assessments of family members abroad to inform care planning and care proceedings in the UK. For example, we might be asked to arrange an assessment of grandparents for a child subject to care proceedings in the UK, to make a recommendation on whether the grandparents residing, for example, in Ghana, are suitable to care for the child. And finally, we also arrange post-placement services. This includes post-placement visits, and we can also seek information on support services abroad, depending on your cases. And so the way we do this is via what's called the International Social Service Network. This is also referred to as ISS. So CFAB is the UK representative of that network, and the network comprises of a general secretariat, which is based in Geneva, and our partner agencies, which are in approximately about 130 countries now. I can see that it says 120, but I think we've got about 130 countries that we work with on a voluntary basis. So some of our partner agencies are statutory agencies in other countries. In other countries, they're charities like CFAB. And the premise of the network is that locally based social workers are best placed to conduct social work in their country because they have knowledge of the laws, of customs and cultures, as well as the social and political context of their country in which they live and practice. So this means we do not send social workers, we do not send UK social workers abroad. Instead, we work with our partners in other countries to arrange local social workers to provide case services on the request of UK local authorities. So given the type of work we do, we have got specialist knowledge and understanding of international kinship care cases. I'm going to pass you over to Maria now, who will provide you with a definition of international kinship care and tell us a bit more about the research and outcomes for children.
Thank you, Fiona, and good morning, everyone. Hope everyone can hear me okay. So what do we mean when we talk about kinship care? As is well established, we're talking about relatives or friends who raise children who cannot safely live with their parents. And across the UK, more than 180,000 children are living in kinship care. So that may be by informal arrangements, but many children are looked after. There are also children who live with kin under private law orders. So kinship care can take place in a variety of different frameworks or a lack of a legal framework. What we know about kinship care is that it's widely unrecognised, underappreciated, and often poorly supported. And the majority of children living in kinship care experience poverty. And that's true of kinship care in the UK. What we'll see in this presentation is that many of the challenges experienced by children living in kinship care and their carers are likely to be heightened where children are placed with kin overseas. But this is a significantly under-researched area. CFAB's inquiries with local authorities have revealed that international kinship care, the placement of children with kin living in other countries, is not always explored as an option for children. And so one of the aims of this training is to raise awareness of international kinship care and how overseas placements can meet children's best interests if they're appropriately explored and well supported. So I'll now hand back to Fiona.
Thanks, Maria. Just at this point, I'd like to refer you to one of our key resources, and that's the International Kinship Care Guide. You can see here a good guide for professionals placing children from local authority care with family members abroad. This guide was published by CFAB along with other members of the cross-border child safeguarding working group in November 2020. So it's quite recent, and much of what we talk about today is outlined in this guide, and this guide also provides more detailed information on this specialist area of practice that we don't have the scope to cover today. So if you're interested in more details about international social work practice and international kinship placements, then this is a good place to start. So let us now think about some of the advantages. I want to talk about the advantages and disadvantages of international kinship care placements. So just let's start thinking about some of the advantages of potential advantages of placements. And I would say that firstly, in some cases, the child will have a more established relationship with family members overseas, and this may help to maintain and promote healthy attachments. We could also consider that a kinship carer may be strongly committed to the caring role due to the familial relationship, and as they might be a grandparent, an aunt, or an uncle, close relation of the child to the child. Kinship. Another advantage is also that international kinship care placements ensure that more often than not, the familial and cultural and social identity is maintained and nurtured. And finally, a child's placement with a family member can ensure that the child remains within the family, and this may, although not always, help to maintain ties and relationships between the child and the birth parent, as opposed to adoption. But clearly there are also a number of disadvantages, and some of these include the fact that the child is removed from their community, which the community in the UK, which means that their ties and relationships can be severed to a large extent, although communication relationships can be maintained by virtual means. There can also be challenges ensuring the child maintains their relationships with their parents or other significant family members in the UK if they are placed abroad. And the capacity to maintain or foster these relationships are often and primarily reliant on the carer abroad managing this contact. And if this doesn't happen, then the parents and family members may not have the means or recourse to request it, depending on when in the country where the child is placed. Clearly, we also need to consider that the child is placed in a foreign environment. So this means that they have to adapt to social and cultural differences, and including different food and weather. Perhaps they are moving from a city to a rural community. So there will be significant differences in everyday life, and where there can be different rules and expectations around children's gender, religion, and family life. So this can be a lot of change for a vulnerable child to deal with. The other very significant point to consider is that infrastructure in some countries may be less robust and available than they are in the UK. So there would be less support for both child and carer than there would be in the UK. And this is a matter that comes up really for all children, but specifically for children with disabilities or complex needs. And finally, it's quite logistically complex to place the child with a family member abroad, as you need to engage with foreign authorities to seek information to feed into your care planning. I'm sure you can all think of a number of other advantages or disadvantages of international placements, but this is what some key ones that I've highlighted here. And you can see that there is a lot to consider when you're looking at the option of an international kinship care placement. So I'm going to hand you over to Maria now, who's going to provide you a bit more background on, will provide you some background on the legal frameworks that may apply in cases of this nature.
Thank you, Fiona. So we're going to talk about the law in this context. When you're working with a family with international connections, you might find that there are legal challenges associated with doing the sorts of things which you would consider to be routine if you have a child who only has domestic connections. So you might find yourself in a situation where there's a question over whether a court can make a decision about a child who has significant connections overseas. You might find challenges associated with getting information on a child's background or connections to another state. Perhaps there'll be a legal question about whether any order made at the end of care proceedings will be recognised in another country. Rightly or wrongly, legal issues can really impact on social work practice in this context. And for that reason, we think it's quite important to outline the legal framework surrounding international kinship care so that we can provide practitioners who are working with children with international connections a greater understanding of the broad context in which they're working and some of the restrictions and challenges that they may experience. So a key legal instrument that we will be referring to in this presentation is the 1996 Hague Convention. And this is an instrument which applies between the UK and a number of other countries which we refer to as contracting states. And importantly, it applies between the UK and all of the other EU member states. Following Brexit and the end of the transition period, the 1996 Hague Convention is the main legal instrument which applies to care proceedings with an international element. And it replaces an EU regulation called Brussels II Revised or Brussels IIa. So that is the instrument, that is the legal instrument that I will be talking about primarily in this context. What does it do? What does the 1996 Hague Convention do? Well, it performs three core functions in care proceedings. So its first function is to tell us which country has jurisdiction in relation to a child. And this is another way of saying which country's courts have the power to make decisions about a child's future. This might sound like a technicality, but it's very, very significant from a child's point of view. Without these rules, you can have a situation where courts in two different countries make conflicting decisions about a child. Or to reverse the situation, neither country accepting responsibility for a child's protection. We know also that jurisdiction can have a life-changing impact on a child. So, for example, in the UK, we have non-consensual adoption as a possible outcome at the end of care proceedings, whereas this is less prevalent in other countries. So if a UK court decides it has jurisdiction, it has the power to make decisions about a child, the case might conclude with the child's placement for adoption, whereas that's less likely if the case is decided in a country where adoption is less prevalent or less common. Secondly, the second core function of the 96 Hague Convention is to enable cross-border cooperation between centralised bodies called central authorities. So in a domestic case involving a child who only has connections to the UK, there's often a lot of information that you need in order to plan for the child's future. You need background information about them, you need assessments of kin, you need information about what supports they need after proceedings have finished. How can we do this for children who have international connections? One way is to make a request for cooperation through these centralised bodies called central authorities, to gather information and exchange information with different countries. And I'll be talking a bit more about that in a moment. And the third core function of the 96 Hague Convention is recognition and enforcement. So at the end of any care proceedings, the court will make an order which provides a form of legal permanence for a child. So that might be a special guardianship order, it might be a child arrangements order, and so on. The 1996 Hague Convention can be used to make sure that legal permanence is achievable for children who will move overseas to live with a family member at the end of care proceedings. So in theory, under the 1996 Hague Convention, any order, child arrangements order, special guardianship order made at the end of care proceedings, placing a child with family overseas should be recognised in that country if it is a contracting state to the 96 Hague Convention. So the contracting states, as I mentioned, they are all the EU member states. We have a list here. There are also a number of contracting states outside of the EU. And you may work with children who have connections to some of these countries, for example, Australia, Russia, Ukraine, Turkey. So there are a number of states outside of the EU which are also contracting states to the 96 Hague Convention, but new countries sign all the time, so it's worth checking in each case. I mentioned earlier that one of the three core functions of the 96 Hague Convention was to provide a framework for cooperation between central authorities. In a case involving a child with international connections, there are actually a number of bodies who might support this kind of cross-border cooperation. And I've outlined on this slide some of those bodies. We'll be returning to this later in the presentation, but in brief, as Fiona has outlined, CFAB can provide social work services through the International Social Service Network. And we operate in a number of countries across the world, not just in 1996 Hague Convention contracting states. By contrast, central authorities are designated by the 96 Hague Convention, and so only operate in these states. And you can see that the functions that CFAB and central authorities perform are quite similar in some respects. You can also find that embassies and high commissions based in this country can be helpful in providing information about other countries, helping to identify potential kinship carers overseas, and supporting foreign nationals living in the UK, which is their core consular function. There's also ACRO, which is the central authority for the exchange of criminal records, which you might need to use if you need to do a criminal records check on an individual who has previously lived in another country. And there's the Foreign and Commonwealth Office, which supports British nationals overseas, which is less commonly used in the context of international kinship care, but is nonetheless an important body to be aware of if you're working with a child who has international connections. So we're now going to look at the 1996 Hague Convention in the context of care proceedings by looking at a case study, because it's much easier to see how this instrument works in practice when you're thinking about an actual scenario involving a child. So this case study involves Lina. So Lina is an Italian citizen born in Italy in 2015, and both of her parents are Italian. She travels to England in June 2020 as her mother formed a new relationship and her father remained in Italy. She starts school in September 2020 in England, but her attendance is poor and she often comes to school hungry and unkempt. Lina's mother reports domestic violence in her relationship, but won't separate from her new partner, and there are multiple police call-outs over a short space of time. The mother refuses to engage with the local authority. Lina's father's unwilling to care for her, and there are no other family members in the UK. And so the local authority issue care proceedings in January 2021, and Lina's placed in foster care under an interim care order. Lina's grandmother in Italy contacts the local authority as she wishes to care for Lina. So here we have an Italian child who's lived in England for about 6 or 7 months and goes to school here. And we're thinking about how these care proceedings will operate, and we're thinking about exploring the potential placement of Lena with her grandmother in Italy if she can't return to the care of her mother. And so the first question that the English court will need to ask itself is whether it has jurisdiction. Does it have the power to make long-term decisions about Lena and what is in her best interest? And this is the question of jurisdiction which we spoke about arising under the 96 Hague Convention. So the main basis upon which the courts can exercise jurisdiction under the 96 Hague Convention is the child's habitual residence. So the judge will be asking themselves, where is Lena habitually resident? Is Lena habitually resident in England? Do I have the power to make decisions about her future? The question of habitual residence is not defined, but case law tells us it's the place which reflects some degree of integration by a child in a social and family environment. So the court will be thinking about Lena's integration into a life in England. So she's attending school, but her experience has been unsettled. She came to England as part of a planned relocation from Italy. All of these issues are relevant to her habitual residence. If the court decides that Lena is habitually resident in England, it can decide what is in her long-term best interests and go on to determine the care proceedings. Let's say the court thinks Lena is still habitually resident in Italy, though, because her connections, her integration in England is not strong enough to decide that she's habitually resident here. Unless one of the other jurisdictional grounds in the 96 Hague Convention apply, then if Lena is habitually resident in Italy, then the Italian courts will need to make decisions about what's in her best interest. However, the English court can take urgent protective measures. It can take steps to protect her in the short term, and those protective measures can be recognised in Italy. So this is a way of the courts ensuring that Lena is safe in the interim, making sure that she can safely return to Italy, so that the Italian courts can make decisions about what is in her long-term best interest. So even in these circumstances, the 96 Hague Convention enables courts to protect children, even if they're only here for a short space of time. So let's assume that the court has found that Lena is habitually resident in England. We need to think about how we can gather information and evidence from overseas about her life in Italy and her connections to Italy. There are a number of steps we can take, which might have already been done at a pre-proceeding stage, but if not, they can be done within the care proceedings. So the first thing we should think about is notifying the Italian embassy that care proceedings have been issued about Lena. And the reason for that is that Lena is an Italian national, and it's considered good practice to notify embassies in these circumstances, unless to do so would place the child at risk. And there's guidance on this issued by the International Family Justice Office. We might find that the embassy is then able to help support the care proceedings, is able to provide information, is able to support Lena's parents through the care proceedings. So it can be a useful step to take in a lot of cases. The other thing we need to think about is whether Lena had any contact with social services or child protection authorities in Italy. So we can do these kind of record checks through a cooperation request, which can take place through CFAB or can take place through a central authority. It can also take place directly. So there are various methods for doing this, but local authorities often find that it's easier to go through a body in the UK, for example, the Central Authority or CFAB, to get this information. And this can tell us if there were previous child protection concerns about Lena or previous court proceedings. Looking forwards, we might want to think, when we're thinking about options for Lena's future, we might want to do criminal record checks in relation to Lena's parents as part of any assessment that is undertaken. And this can be performed through the ACRO Criminal Records Office. And then looking forwards, we might want to think about assessing Lena's grandmother in Italy, which Fiona is now going to talk about in further detail.
Thanks, Maria. So let's now think about how we can arrange an assessment of a family member or prospective carer abroad. I mean, this can be tricky. There are often many elements to consider. And what we'd say is before you start, you need to consider firstly nationality. The nationality of the child and the prospective carer can determine the type of assessment required in care proceedings, i.e. whether it has to be a kinship assessment or whether the only option is to look at placing this child under an adoption order. Then you would need to do an adoption assessment. It also helps us to understand the practical viability of an overseas placement. So I say this as we need to consider a child's right to remain in the country on a permanent basis. So, for example, if we're placing Lena with her grandmother in Italy, we'll need to be certain that Lena can legally reside in Italy on a permanent basis based on her nationality and her immigration status, as well as her grandmother's. And this is, and as we know, Lena and her grandmother are both Italian citizens. Therefore, the matter of nationality and Lena's right to reside and the permanency of this placement in that respect is secure. If the local authority wants to place a child with a family or member or a significant person in the country and the child does not have legal right to remain in the destination country, then the local authority would firstly need to seek legal advice and to find out if the child can secure a legal right to remain in the country under the terms of a kinship arrangement, such as an SGO or child arrangements order. And if there's no option for the child to remain legally in the destination country under the terms of a kinship arrangement, then the option of adoption could be explored, as this might be the only means of securing the child's legal right to remain in the country. So you need to know really early on what order the child will be placed on in order to determine from the outset the type of assessment that you require. You should also think about what happens to the child's immigration status if the placement breaks down. And we say this because in some cases, the child may not be able to remain in the country as their immigration status might be dependent on the prospective carers sponsoring them. So in which case you need to consider from the outset the local authority's legal duties and responsibilities should that placement break down even 3 or 4 years after the placement. But as I said, in Lena's case, she's an Italian citizen and her mother is also Italian, so we can be certain that she has legal security and can be placed there under a kinship assessment. So let us consider how to arrange the assessment of Lena's grandmother. In the UK, we nearly always first conduct an initial assessment, followed by a full assessment, being an SGO assessment or perhaps a connected persons assessment. And when you're thinking about conducting an initial assessment, there are a few options that you might want to consider. And would generally recommend it's possible for the UK social worker to conduct the initial assessment by virtual means. You may need an interpreter to help with this, but the advantage of this approach is that you can manage the assessment process yourself, and you can maybe gain a good understanding in a short period of time to determine whether this is an option to proceed with a full assessment. Clearly, there might be some disadvantages of this approach, and there could be a risk of cultural misunderstanding, and when you're working across cultural divides. You might also have problems with communication, understanding one another, and there could be technical difficulties, such as poor telephone connection. The other option is to arrange for a locally based social worker to conduct an initial assessment, and this might be able to be arranged by CFAB, the central authority, if it involves a country signatory to Hague 96. For CFAB, obviously, we work outside Hague 96, but if you're going to the central authority, it would be involving a country that's signatory to Hague 96, or you may be able to identify a social worker in country who can assess you directly. But the challenges in a local social worker doing the assessment is, in some countries, there's no difference between an initial assessment and a full assessment. So whilst you may ask for an initial assessment, what you receive back may be what they consider to be a full assessment. And we would say primarily the issue is that local social workers and arranging local social workers to assessments abroad takes time to arrange, and it could lead to delay if you're then asking for another full assessment to be completed. So we generally recommend doing an initial screening assessment by telephone, if possible, before proceeding with a full assessment. So the options for seeking an assessment from abroad, we have detailed here. You could go to the central authority in England, that is called ICACU. If it is a country that is signatory to Hague 1996, you could come to us, to CFAB, and we would do our best to help you in arranging the assessment. In some cases, you might be looking at working with an independent social worker or the social worker here travelling abroad. And in some places, local authorities have got contracts directly with statutory agencies in other countries to assist them in doing their assessments. So there's a lot of options that you can consider. Some of the pros and cons of having a local social worker doing an assessment, completing assessment for you, we've outlined here. So what I mean by a local assessment is a local social worker, for example, in Lena's case, a local social worker in Sicily conducting the full assessment on your request. Some of the pros would be that the local social worker would understand the culture and context of the placement and the services. They would understand the environment and law. They will know how to access records, social service checks. They'll know how to verify information. You'd expect them to have understanding of the documents that are presented during the assessment process. They may have local language skills that would help them to communicate, and may help them to build a rapport with the prospective carer. And there's no legal issues regarding their right to work in the country, because they can legally work in the country as a social worker. Some of the cons or disadvantages is that quality of assessments from abroad can vary greatly. We at CFAB always try to be upfront as possible about what you can expect to receive back from each country we work with, but it is something to consider that the quality can vary greatly. Assessors will not always have an in-depth understanding of the child and child's circumstances. They're going to be to have that understanding based on the information that you provide to them as part of the referral or the court documents. And in general, they don't have an understanding of UK procedures, laws and regulations. And because it can take a longer time to arrange assessments from abroad, they are prone to delay, so it can impact timescales. That said, I can say that CFAB has an exceptional social worker in Sicily, in Italy. She is Italian, but trained in both the UK and in Italy and registered in both countries. So she is an exceptional case. But yeah, we can offer a very good service there, just to add. One question we're often asked is it legal for UK social workers to travel abroad to conduct assessments, and are they able to? So firstly, is it legal? Can the social worker legally work as a social worker in another country and conduct the assessment? And what you need to consider is whether there is a registration body for social work practice in that country, and whether the social worker can enter that country and work on a tourist visa, or whether they need to secure a specific visa for this purpose. You also need to consider if the right notifications are being followed for the placement. It's a requirement for local social worker, perhaps from the statutory agency, to complete the assessment in order for it, in order for the carer and child to access resources in country. Meaning in some countries, a local social worker has to complete the assessment in order for it to be recognised by children's services in that country. Thirdly, what are the risks? What are the risks, firstly, to the child? Our partner in Hong Kong has said that a foreign social worker, for example, entering a village in mainland rural China, would bring a lot of attention to themselves and to the prospective carer and the child if placed, and that attention may follow the child who could be stigmatized by the community as a child who's required foreign intervention, and that could follow the child as they enter into school and be really detrimental to their well-being and the security of the placement. But in addition, what is the risk to the social worker? They may not be protected by law if they are working without the correct visa and without the correct permission, nor may they be covered by their insurance provider if they are not working lawfully. And finally, is it ethical? And the question here is whether you need to have an understanding of the local context, laws, and culture in order to do your assessments. And best practice would generally indicate that you do need this knowledge. Here is some feedback we have received from our partner agency in Canada when we've asked them about what their views are on social workers from the UK travelling to Canada to conduct an assessment. You can see they have quite strong views. They say they question whether it is morally wrong, and their views are very strongly the case that a social worker has to have an understanding of the local context, the laws, the culture, and the structure of services in order to conduct an assessment. And they would need if they're coming from abroad, that they would need a working visa. In South Africa, this is our partner agency in South Africa, which is also the statutory agency for children's services in South Africa. They have advised us it would not be legal for a social worker to do any type of social work involving clients or prospective carers in South Africa, and that is prohibited under law, under the Social Service Professions Act in South Africa. So what then? We recognise that you cannot always get a very detailed, a substantive assessment report from all countries worldwide that we need here for the UK for the purpose of making an informed decision for a placement of a child. And some of the possible approaches could be a split assessment or a joint assessment. And a split assessment, we're often asked, would involve part of the assessment being done by a local social worker in country and then part of the assessment being done by a social worker based in the UK. We're often asked to arrange this, so the part done in country would be the visit to the home, information on resources, information on any cultural aspects of the placement that need to be considered, and then part of the assessment may be done by either virtual interviews or arranging for the social worker, for the prospective carer to come to the UK. The other option that we have here is a joint assessment, and that would be a social worker from the UK travelling out to do a piece of work jointly with a local social worker based in country. Obviously, some of the challenges still remain regarding legal right to work in country, but where this is possible, this might be an option to consider. We offer this in some countries. It's very rarely an option that local authorities take up, but it is something that we can arrange in some countries. Right. So, placing children overseas. I believe I'm handing back to Maria to assist with us on this section.
Yes, so thinking about placing a child overseas. So we're going to think about some of the technicalities and some of the legal requirements which might arise in these circumstances. One of the requirements of the 1996 Hague Convention is to seek consent from overseas authorities before placing a child in another contracting state. And the convention says that consent will be required for placement in a foster family, placements in kafala, which is a form of alternative family care, which you find in some countries which have a Sharia law system or inspired by a Sharia law system, in institutional care or analogous institutions. So it's not entirely clear from the 1996 Hague Convention whether kinship placements, for example, under special guardianship orders, fall within the scope of Article 33 of the 96 Hague Convention. Because, I mean, we might not think that these placements would constitute foster placements. But the thing is that other countries may view these placements as falling within the scope of Article 33 and may consider that their consent is required before children are placed overseas in their contracting state. So guidance from the former president of the Family Division, Sir James Mumby, said that it was for the other country to decide whether the placement is one which requires their consent. But there's contradictory guidance from the Department for Education on the 96 Hague Convention, which says that special guardianship orders do not require this consent. However, I would say that that is quite out of date guidance from 2012. To err on the side of caution, it's probably a good idea to check with the Italian authorities, if we're thinking about Lena's case, to check with the Italian authorities whether a special guardianship placement with Lena's grandmother would require consent under Article 33 of the 96 Hague Convention from the relevant child protection authorities in Italy. And we can do this by contacting our central authority in England and Wales, ideally at an early stage in the proceedings. And if consent is required, we need to transmit a report with reasons for the placement and seek their consent. And at the same time, it's a good idea to think about what post-placement support you might need from that authority if you're expecting them to do anything if Lena is placed in Italy. The reason why it's important, and the reason why I'm talking about this in this training, is that a failure to obtain consent could lead to non-recognition of the order. So let's say we want to place Lena with her grandmother in Italy under a special guardianship order. The Italian authorities say they must consent to that placement before Lena is placed, but we don't get their consent. we place Lena anyway, or the court places Lena anyway, under a special guardianship order, the Italian authorities would be entitled to refuse to recognise the special guardianship order because we have not obtained the consent we should have obtained. So that could have serious implications for the child and the carer, as it would lead to their parental responsibility not being recognised in the country where the child's living. So the message from this provision really is to check with the central authority before a child, when you're thinking about placing a child overseas, to see whether you need the consent of the relevant authorities before the child travels. So let's say that we've clarified through the central authority that consent is required for Lena to be placed with her grandmother in Italy. We've transmitted a report with reasons for the placement, and the Italian authorities have come back through the central authority and have said that they consent to the placement. We're thinking about a special guardianship order for Lena, for Lena's grandmother. What will be the status of this order when Lena moves to Italy? Will the special guardianship order be recognised? Well, if we think about the three core functions of the 96 Hague Convention, which I spoke about at the beginning, the 1996 Hague Convention tells us that a court order made in relation to a child in one contracting state should be recognised in another contracting state. So an order made in the UK, a special guardianship order, should be recognised in Italy. However, there are additional steps that can be taken to provide certainty around recognition. For children who are placed in non-contracting states, we can't use the 1996 Hague Convention to guarantee recognition of our domestic order. So let's say Lena was going to live with her grandmother in Russia, not Russia, her grandmother in Canada. We wouldn't be able to use the 1996 Hague Convention to recognise our English SGO. So in these circumstances, we would need to think about a mirror order. And a mirror order is an order made in the country where the child will be living, which mirrors the terms of the English order. And it requires legal advice from a lawyer qualified in the relevant country to determine the procedure and the costs for doing that. We at CFAB have produced a fact sheet on placing children in non-contracting states, which contains further information about this. So we've said that orders made in one 1996 Hague Convention contracting state should be recognised in another. However, we know in practice this might be easier said than done. And a carer with an English special guardianship order living in another country may encounter difficulties in ensuring that that order is recognised and their parental responsibility is recognised and that the order is upheld. The 1996 Hague Convention permits applications for recognition and enforcement of orders from other contracting states. So Lena's grandmother could seek from the Italian courts a decision or an order recognising her UK special guardianship order. If Lena's mother tried to remove Lena from her placement with her grandmother, Lena's grandmother could apply to enforce her special guardianship order. So could apply to the Italian courts for an order confirming that Lena should be in her care. It's technically possible also to seek a decision on recognition before Lena moves to Italy, and this is known as advance recognition, and it's possible under Article 24 of the 96 Hague Convention. But there are no timescales for overseas authorities to provide a decision on advance recognition, so this might cause some delay, but it might be helpful in some cases. Overall, special guardianship orders may not translate well in other countries, unlike child arrangements orders. This is not necessarily a reason not to make a special guardianship order, but it might be necessary to set out the rights that it gives the carer in relation to the parent, because many other countries do not have an equivalent of a special guardianship order in terms of the specific rights it gives the carer. So we're now going to think about how we can support an overseas kinship placement. And we're also going to think about local authority obligations to support a placement in another country. Why is it important to support an overseas kinship placement? Well, we discussed that kinship care is often unrecognised and underappreciated. Research tells us that placements which are poorly supported are more likely to break down. Where carers are experiencing stress, there's more likely to be a breakdown of a placement. There's data on placement breakdown rates in the UK. So we know that around 5% of special guardianship orders might break down. The figure is higher for child arrangements orders and lower for adoption. And that might seem like quite a low breakdown rate. But when we're thinking about a child going to live overseas, the consequences of a placement breakdown can be highly significant, because we need to think about, well, if this placement breaks down, where will the child go? Do they have any other connections to this country other than the carer who they're living with? Will the child end up in a state child protection system in that country? The consequences of an overseas placement breakdown are very significant, and for this reason, we need to think about ensuring that a placement is properly supported and careful contingency planning in the event that the placement does break down.
Okay, thanks, Maria. So let's now think about this from a perspective of a social worker who's planning to place a child in the care of a family member overseas, and what do we need to consider? So this is what we suggest. You should consider how the order will be recognised and mirrored, and what support you'd provide to the carers to assist with this process. That might be helping them to get a lawyer in country, or paying to help pay for some of their fees to get that order recognised or mirrored. You may need to consider what support should be offered to the child and carer. Well, you will need to consider what support needs to be offered to the child and carer pre-placement. For example, you may be looking at doing life story work with the child, while the carer may need to make adjustments to the home, purchase furniture, toys, or belongings for the child. The carer also need to know about the child's routines and have a really good understanding of the child's needs. Obviously, that should have also been shared as part of the assessment, but you'll need to have to consider how any of this additional information will be shared with them. You also might need to consider what training the carer may need pre or even post placement. For example, carer may need specialist training around impact of trauma, and what this could have on a child's attachment, or training to understand the, for example, substance use may have on a child's development. We say that it's very important that that the carer is informed of the rights to ongoing support from the local authority, and they know how to access this. So you need to consider who will share this information, and where this information will be documented. We have found that often when a child is placed overseas, that the carers do not know how to access support if they need it. And they may not even know that they're entitled to additional support. So this is really important for carers to know, especially when there's challenges or difficulties arising in the placement. You also need to consider what services are required for the child once placed, and who's responsible for providing those services. For example, will it be the overseas authority, or will it be your local authority? And you may need to consider making referrals to either overseas authorities or UK authorities to put this support in place. And you would need to confirm that you have cooperation agreed by all parties involved and all services to support this placement, and give those services sufficient time to put those supports in place. I would also add that you should consider what the arrangements would be for monitoring and the delivery of the services, and specifically what will happen when the local authority ceases to be responsible for this, and who will assist the carers if they encounter difficulty in accessing services and support. Who's their point of contact? Clearly, you need to consider how much financial support, if any, the carers require, and if for how long they would require this support. And the carer obviously needs a copy of the care plan, details of who to contact, and where to find out more information about their rights for entitlements, such as their rights as special guardians. When you're planning support pre-placement, you need to also consider how the UK social worker and the child and carer can access post-placement services. Well, I think I've gone ahead. So let's just move on to the next slide. I'm so sorry. Yeah, so you have to consider how you're going to access support for these services, and there's obviously a number of options. And again, that you can go to CFAB, the Central Authority, maybe the ISW who completed the assessment, or private social work agencies, or maybe if you've got direct agreements with children's services and embassies, another really good point of contact if you're wanting information on what supports are available post-placement. So let us return now to the story of Lena and thinking about post-placement supports for her cases. So having decided that Lena should be placed with her grandmother under an SGO, the local authority identified the aunt as a contingency carer. And in this occasion, they did this by way of a separate assessment of the aunt that was completed by a CFAB. The local authority also planned support for Lena's placement, including providing financial support based on a means assessment. They arranged therapy for Lena through a referral to local social services in Naples, and this was arranged by CFAB. And they assisted the grandmother with managing a structure for Lena's contact with her mother. The local authority also sought consent through the Central Authority for the placement under Article 33 of the Hague Regulation, and consent was required and was provided by Children's Services in Naples. The social worker in the UK provided Lena's grandmother with all the relevant documents, including a copy of the court order, and all these documents were translated for the grandmother. The local authority obtained legal advice as well on the recognition of the UK SGO in Italy, and supported the grandmother, ensuring that the order was recognised there. The local authority also commissioned CFAB's partner agency in Italy, and that being CFAB's social worker in Italy, to conduct 6 post-placement visits in the first 3 months. And in addition, the local authority informed Lena's grandmother how to access further supports post-placement, and who specifically to contact and how. And just finally, the local authority also agreed to ensure that relevant Italian authorities, who the local statutory agency for children's services, so the agency with the child protection function, are informed that Lena has been placed in the grandmother's care to safeguard against any breakdown, meaning basically that they made a referral to statutory agencies in Italy via CFAB to advise that Lena was to be placed in her grandmother's care. Now passing you back to Maria.
So Fiona's outlined the post-placements aspect of Lena's journey. I think it's important just to remember that at the outset of the proceedings, we spoke about jurisdiction, we spoke about the court's power to hear the case concerning Lena, and also the cooperation that the local authority engaged in to obtain background information on Lena through various other agencies, because these initial steps can all inform the later steps taken in relation to Lena planning for her to live overseas. Without that background information, we don't get a full picture of Lena's life. And I think it's quite important to recognise that children with international connections, you may not always have the full picture. You might be reliant upon the background as reported by the parents, unless you seek to verify background information. I know that in my research, I've encountered many cases where parents have not disclosed the existence of previous child protection interventions overseas. And these interventions have only come to light after a local authority has made a cooperation request overseas, whether through the central authority or through CFAB. But here, basically, we do have a summary of Lena's journey, so you can see how the legal and social work aspects of many of the matters we've discussed today play out in a case example. So I'm just going to, or Fiona is going to summarise key messages from today's presentation.
Okay. Thanks, Maria. So we've tried to cover a large. We've tried to cover a lot today and in quite a short period, and we're hoping that these are some of the key points that we'd like you to consider, and that includes to notify and seek permission to place the children abroad, and that is necessary if placing children in a Hague 96 country, but it is good practice in all placements. We really encourage identifying prospective carers early on as possible, and that's because international assessments and international placements can take a bit longer to arrange and can be a bit more complex than placements that are done domestically. We have emphasised the need to consider the child and the prospective carer's nationality and immigration status and early on, because that determines in some cases what type of assessment and what type of court order would apply. What type of assessment is needed, depending on whether it would have to be an adoption versus kinship. And as I said, you need to take into account longer time frames when arranging assessments from abroad, and this, in sometimes an exception to the timetable or an extension to the timetable might have to be requested, as it's understood that these are often do take longer than domestic assessments. We really have emphasised the need to ensure the court order is recognised and mirrored, and explained how that can be arranged. And we've talked about how to consider and prepare child and carer very briefly, I'd have to say, for the placement, and the need for a comprehensive care plan, including how to transition the child into care. And we've sort of focused on post-placement support services to the child and the prospective carer, and making sure that the carer knows how to access support, and ensuring that there's a contingency plan in place should the placement break down. Maria, back to you.
So here are a few resources which you might find helpful if you have a case involving international elements. I won't go through all of them, but you can see there are some bodies. So you have the contact details for CFAB, central authorities, and foreign consulates. If you follow these links, when you access the slides, these will be hyperlinks. There's guidance for local authorities. It's non-statutory guidance, but guidance nonetheless. There's not a huge amount of information and support available, so we sort of cling on to these DFE advice notes because they can provide some useful pointers. There's some legal resources. There's the practical handbook about the 96 Hague Convention. There's guidance on the impact of Brexit in this area, issued by the Ministry of Justice. And then finally, these three core guides. So we have the International Kinship Care Guide, which Fiona mentioned at the beginning. a guide by the Family Rights Group to initial family and friends care assessments, which does have a section on international assessments. And we have the recent guidance from the Public Law Working Group about special guardianship orders. And it touches on international cases, but it really emphasizes the importance of robust assessments, contingency planning. And it's often quite difficult to implement that in practice in a cross-border case. So we hope that today's training has highlighted some of the areas which might need particular attention when you're dealing with a child who has international connections. I'd just like to let you know about the legal advice service, which I'm running at CFAB. So I'm running a pilot scheme for local authorities to support them with international issues in a child protection or care proceedings context. So if you have a case involving an international element and you would like to use the service, you can contact me and I will see if the case meets our criteria. I can provide you with a free letter of advice, which hopefully will explain some of the legal aspects and will signpost you and provide some quite tailored signposting and resources, which will hopefully support you, because these cases can be complex. So please feel free to contact me about the legal advice service if you have any legal questions arising from any of your cases which you would like to know more about.
I'd just like to add as well that our legal advice service is quite separate from CFAB's social work advice line as well, and our social work case services. So the advice that Maria provides from CFAB is independent from any cases or casework that you may have with us. Yeah, so we've got a few questions that have been sent through to us. If anyone wants to send a few more questions through, we do have time, and we can do our best to answer them. I can see one question that we've been sent is being asked, what happens to the child and or prospective carer having dual citizenship? I mean, everything's on a case-by-case basis. You would need to consider, I understand perhaps this is in reference to regarding whether a child can be placed with the family member. Without further more detailed information, it's a bit hard to answer. You do need to consider, what I would say, that there are cases of children that may have rights to two different citizenships, but in some countries they will only let you hold one. So if they are placed with respective carer in another country, that may impact on their rights to retain their citizenship here, and that would be dependent on the law in the destination country. So we don't provide legal advice on immigration matters, but we would say that that is something that you'd need to consider closely and that you may need to seek immigration advice. I can see that there's been another question sent through asking in what way an assessor would not have an understanding of a child and case circumstances if the referring organisation and social worker had not provided such, and that you felt like it was quite a negative. I'm sorry, that's not my intention. I guess the difference is a social worker overseas is not having direct contact with a child here in the UK, and in some cases, so social workers overseas, they do not receive the full case bundle. They're receiving information, a limited case bundle. So we do get very good assessments from overseas. It's no negative critique of our social workers. We're very proud of what our social workers overseas, we're proud of the work they do, but we do want to emphasise that the type of assessments we get from overseas do vary greatly.
I think I would just add to that I think it's right that if you outline comprehensively the background circumstances of the child, then that will really assist with the production of an assessment which takes those matters into account. And so that is when we encourage local authorities in relation to the referrals that they make, we do encourage a comprehensive background. Sometimes some of the feedback that we have from social workers when we do training is questions around how could an overseas social worker produce an assessment of a kinship carer when they don't know the child, when they haven't met the child, and the sense that that might be quite a different experience to reading about the child on paper. And I mean, that is just one of the challenges of cross-border assessment, and one of the ones that we have to address, hopefully through some of the issues that we've spoken about in this training.
We have a couple of other questions.
I
don't know for you to answer, Maria, maybe.
Yeah, there's a couple of sorts of legal questions. So one is, if a kinship order has been granted in another country, is this accepted in the UK? And so the 1996 Hague Convention applies both ways. So let's say you have an order relating to a child made in France. That order should be recognised in the UK. But again, an application could be made to the English court for a decision that that order is recognised. And so we do have incoming cases as well as outgoing cases. I just haven't spoken about them that much because the primary focus has been on overseas kinship placements. But at CFAB, we do encounter incoming kinship placements, and often carers experiencing challenges with the recognition of the order that they have from their home country. But yes, I mean, then if it's a contracting state, if it's a 1996 Hague contracting state, the order should be recognised in this country. If not, then consideration would need to be given to applying for a domestic order here, which gives the carer the rights they need to look after the child. Sorry, Fiona.
I think the next one is for you as well, Maria.
There is a question, so not a kinship care placement, but if we are wanting to place a child with a parent outside of the UK who has parental responsibility, which is recognised in the UK, does an order need to be sought? I think it would depend on the facts, and it's quite difficult to say definitively because the question is an order required? So if, for example, you have a father who has parental responsibility as a matter of the law in the country that he's living in, that's fine. But then do you need to regulate the arrangements in some other way? So do there need to be contact arrangements? Do there need to be provision? Does there need to be provision for supervised contact? Does there need to be provision for other arrangements for the child that might require an order? It's quite difficult to say without knowing more. Sorry, that's not a very helpful answer. But feel free to contact me in the legal advice service if you'd like a more comprehensive one.
The next one, when the parent of a child in the UK passes away in the UK and the family abroad want to come and look after the child in the UK, is there any guidance around this? Well, you would also still need to be looking at their legal right to remain and enter the UK and to remain here in order to care for that child. We do get referrals requesting of this nature where one family member is willing to come to the UK to care for the child, and we're doing part of the assessment in the country, in the country where they're residing, and that might be doing social service checks, history, doing part of the assessment on family members there, who's living in their household at this time, what the home conditions are at this time, and what their sort of motivation and intentions are. I don't know of any specific guidance around these types of assessments. I don't think there is any specific for those specific types of assessments of when a family member is coming to the UK. But I think all the key principles of what you need to consider are similar to what we've discussed here in terms of thinking about immigration, right to remain, and the security of the placement, and making sure you're getting culturally information from the country where the carer, prospective carer, has been residing as well. That's I don't know if do you have anything further to add to that, Maria?
No, I think the key challenge in this situation, though, would be the immigration aspect. And so clarifying whether the prospective carer has the right to live in this country. If they're looking after the child, they'll need immigration advice. Yeah, I don't think there is any specific guidance in relation to that, though. There's a question, Fiona, I don't know if you'd like to answer, whether, I think in relation to the matters you were discussing about social workers travelling overseas to conduct assessments, we have a question about whether this is also applicable to parenting assessments. Can a UK-based social worker undertake a parenting assessment in another country?
I mean, it doesn't. The same issues arise. It's no different if it's a parenting assessment or an assessment of an aunt or uncle or grandparent. The same. You still have got to consider the same issues that we discussed, that I discussed earlier, about whether it's legal. Do you have to be a registered social worker in that country? Do you need a visa to enter that country? Is it, do you have the cultural background or knowledge? Are you following the correct procedures if that is to be a placement? If it's going to be a placement, are you following the correct procedures for that country to ensure the supports that child needs and carer needs can be accessed? But that said, I do believe, we are aware that it is that social workers from the UK do travel abroad to complete assessments. I don't know if we've got any further questions.
We have one question. How would a child obtain citizenship of an overseas country? So eligibility for citizenship, and in fact nationality, is governed by the law of the relevant country. So English law, or British law, I should say, governs eligibility for British nationality and the procedures for British citizenship. And the same is true of other countries. So each country has different requirements. And so we usually suggest that embassies are the best initial point of contact to clarify this, to clarify whether a child can obtain a passport for another country. So we encounter this a lot, particularly in relation to the USA, where it's really important for a child to have American citizenship if there's a kinship placement contemplated, because they will then have the right to enter and remain permanently with the kinship carer. Otherwise, the placement will have to take place by way of inter-country adoption, which I think Fiona mentioned earlier in this presentation.
For all rights to a green card, parents who have got a green card, maybe to be able to support their child. But adoption is a means in most cases for the child to secure the citizenship, but it's not something that we can advise on. We're not able to provide immigration advice. You would have to seek immigration advice and speak to the embassy of the destination country.
I think our last question is whether there's scope for an assessor abroad to meet a child virtually, and whether this is common practice.
I do not believe it is common practice. Most of the children that are placed abroad, I would say, are quite young. In most cases, it wouldn't really be appropriate, and it's not something that has been practiced. It might be more appropriate for an older child who's maybe returning to meet with a family member, but most of the cases we're dealing with are very young children. So if you've got questions about, I've got a question here that they've done from a social worker who said they've done initial assessments but unsure about how to progress to a longer assessment. Please call CFAB's advice line. Go to our CFAB. I think we have it on the earlier slides, but you can contact us and we'll advise you if we can help. If we can't help, we'll be telling you, how else you might be able to get that assessment. We know we've got another question here. Are we aware of cases when a young child was taken abroad for contact with the family, which is being assessed? Yes, it doesn't happen very often. Obviously, there are some. It can be legally quite complex. I don't know if that's something, Maria, that you want to talk about. I mean, the concern would be what happens if the family does not agree to return the child. But we have had some cases where that has happened obviously with the permission of the court. Maria, I don't know if you want to add to that.
Yeah, I mean, I think we're seeing this increasingly as there is an attempt to ensure assessments take into account an observation and analysis of the relationship between a prospective carer and a child. So sometimes this is facilitated by the family coming to the UK, but that's not always possible. And so there are cases sometimes where a child travels overseas for contact, and then there is some kind of assessment while they're overseas. As Fiona says, yes, there's quite a few legal challenges associated with it. It's possible, but the question is really the legal framework for doing it, and also a kind of risk analysis in each case about what is the child meant to be returned at the end of contact? How likely is that to happen? If the child is not returned from the other country, what will we do and what remedies are available? And how can we ensure that the contact, I mean, I think there needs to be a bit of a consideration of ensuring the child's safety, particularly if they're travelling under an interim care order, because of course the local authority will have a statutory duty towards the child whilst they're overseas. How can they meet those statutory duties? These are all some of the challenges that we see in these scenarios. It's possible, and in fact in our International Kinship Care Guide, at the end there is an example of a partnership agreement between a prospective carer and a local authority in precisely this scenario. So it does happen. I think we are drawing to the end of our session. I think there are a couple of questions we haven't answered, and there are some questions which, for example, about the placement of a child in a non-contracting state, Qatar, which I can answer later by email if you'd like. So please feel free to contact me. But I think that draws our session to a close. So thank you so much, everybody, for attending. Thank you so much for your really challenging and interesting questions. It's always really good to be able to think about practical scenarios because every case presents its own unique challenges. And I hope that you will feel a bit more confident about cross-border cases. And of course, feel free to contact us at CFAB, either through the CFAB advice line, which is a fantastic resource. And CFAB social workers have so much knowledge about procedures in different countries and what is available in different countries. Or if you have a legal question, please let me know and I can see if I can answer it. And the slides from this presentation will be provided to everyone. So we hope you find them useful. So unless there's anything further, I will say thank you very much. Thank you for attending.
Thank you.
And goodbye. Have a good rest of the day.